All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Court now calls case number CV130531, Flash Schillinger versus Salmons. This is the time set for oral argument. Counsel, let me advise you, good morning, counsel, that these proceedings are being audio and video recorded, and there's a link to these proceedings that's going to post the video on our court website, so you'll be on YouTube, I guess, at some point in the next few days. Please identify yourself when you get up and also identify your client. You each have 20 minutes to present your case. Counsel for the appellant, if you want to reserve some time at the end for rebuttal, please let us know. As you're well aware, we've read the briefs, we've conferenced the case, so we're very familiar with the issues and your arguments. The clock at the podium will give you a means to keep track of your time. And with that, counsel for the appellant.
May it please the court. I'm John Burrick on behalf of the appellants Floyd Salmons and Diane Galati, husband and wife, Salmons Brothers Framing Incorporated, and SBC Incorporated. We're going to refer to them collectively as the Salmons parties. With me is my co-counsel Robert Macy. The standard of review on this matter is de novo because it's an appeal from a motion for summary judgment ruling. The briefs the parties have presented to the court kind of bombard you with a lot of facts. But the material facts in this case are very few. And the material documents in this case are even fewer. In Appendix 1 to the opening brief, we provided a very simple flow chart of the transactions for the court. I think looking at that will help the court get a good understanding of the direction that the transactions went. Additionally, there's really only 3 documents that the court needs to look at in order to render its decision today. 2 of them are enlargements. They're in the record. The note secured by the deed of trust, which we referred to as the promissory note, the modification agreement, and the long-form guarantee executed by the Salmons parties, which I have in my hand. The appellees were kind enough to provide those in their appendix to their answering brief, and those are Appendix Exhibits 3, 5, and 6. They're also cited to the court record by the appellants. If we first look at the promissory note, which is the document on the right on the easel, Marbach purchased 128 finished lots from Deseret Sky Development and signed that promissory note. Brian Lesk and Floyd Salmons signed that note as guarantors. The only guarantee language in that promissory note on the right is 3 words, personally guaranteed by. That's it. It's undisputed that Marbach has never received finished or buildable lots. That's not an issue of fact in this case, but it is an issue that goes towards whether the appellees, which I'll refer to as the plaintiffs, were actually holders in due course. And we'll discuss that a little bit later. The second document in this case, and probably the most important document, is the modification agreement, which is the document on the left on the easel. If we look at Section 2.3, it says additional requirements in big capital letters. That may as well say extra conditions. And that required new guarantees from Mr. Salmons, his wife Diane Galati, who had never given a guarantee, Salmons Brothers Framing, which had never given a guarantee, and Brian Lesk. The Salmons parties didn't learn until years later, when this litigation ensued, that Mr. Lesk had never given a new guarantee of the form that was intended.
But he had given some form of guarantee at some point.
The only guarantee he gave was that 3-word guarantee on the bottom of the promissory note on the right that says personally guaranteed by. The Salmons parties gave this lengthy 3-page guarantee. Both the modification agreement and the corresponding guarantees of the Salmons parties are invalid and unenforceable. First, if we look at the modification agreement, the document on the left, it has an express condition in Section 2.31. It required that those parties give new guarantees because it says additional requirements.
Where does it say new, counsel?
The word additional.
Additional requirements for the modification, and then 2.31 says personal guarantee. So you're required
Correct.
to give a personal guarantee.
From those parties, correct. And it includes...
So there's some new parties that were included, but what about the parties who already gave a guarantee? Does it say they have to give a new guarantee in that language, or does it just say they have to give a guarantee?
It doesn't specify the form in that particular language. But the case law is clear that when there is an ambiguity, it's construed in favor of limiting the liability of the guarantors. Also, extrinsic evidence is admissible to demonstrate the intent of the parties. Here, there is no issue of fact that the Salmons parties and the plaintiffs and the mortgage company all intended that the individual guarantor sign the same long form of guarantee. The title company prepared the long form of guarantee. It sent it to Mr. Lesk. It sent it to the Salmons parties. It received it back signed from the Salmons parties. The plaintiffs have acknowledged that they intended the long form guarantee to apply to all the individuals. Plaintiffs' counsel has acknowledged on the record that that was the intent of the parties. And the Salmons parties, they relied on Section 2.3 that Mr. Lesk would be providing a similar or identical 3-page guarantee, not just the personally guaranteed by language that's found in the note. The Salmons parties never...
Well, as I understand the record, he's essentially admitted that he signed the guarantee and he was still bound under the original guarantee that he signed.
Well, the problem we get into then is not only the conditions of the modification agreement that weren't complied with, he didn't provide the new guarantees that everybody agrees were anticipated, but it's also a failure of that material condition because Mr. Lesk didn't sign on to the new guarantees as he was supposed to do. We now get to the law.
I guess Judge Berkeley's question relates to what did it matter if Lesk was already bound by his initial guarantee, and he admitted that, and I guess admits that. How does it matter to your clients?
It's the law of guarantees, Your Honor. The law of guarantees say that if you change the obligations of a guarantor without their assent, they're released. The Salmons parties never agreed that Mr. Lesk could do anything other than comply with Section 2.3, which everyone acknowledged was to give a long-form guarantee. By having Mr. Lesk merely subject to the 3-word guarantee, the Salmons parties are disadvantaged. Now, the case law is very clear. The Western...
Well, isn't that really then a fight between all the guarantors? It has nothing to do with the note holder?
No, actually, it's not, respectfully, Your Honor. Western Surety versus Harrell and Indian Village versus Kroger indicate that you don't, as a guarantor, you do not have to prove that you've suffered damage or injury if your obligations have been changed without your consent.
That deals with the debtor's underlying obligation, right?
That deals with the risk or the obligation itself.
You can't change the debtor's underlying obligation without affecting the guarantors. Was the debtor's underlying obligation changed here in the modification agreement? Did you change the principle or anything like that?
Well, yes and no, and it's a tricky question to answer because our court cases, the black letter law says we don't have to prove that. All you have to prove is that they changed the deal without our assent. And here, Section 2.3, upon which everybody agreed, Mr. Lesk was to provide the long-form guarantee. But I will answer that question. I'll give you a hypothetical, for example. Under the long-form guarantee, the plaintiffs could release Mr. Lesk, but still hold the Salmons parties fully responsible for the entire obligation, but not the other way around. Under Mr. Lesk's 3-word guarantee, if the Salmons parties are released, he automatically gets released. And why this becomes a problem is, and again, this is a concept that permeates guarantee law, it impairs the ability, for example, of the Salmons parties to settle the case. Let's say the Salmons parties reached an agreement with the plaintiffs where they wanted to settle the case. The plaintiffs would be unlikely to settle the case knowing that Mr. Lesk would automatically be released if they settled with the Salmons parties, because that's what the long-form guarantee provides.
Make them an offer. We'll find out how true that might be.
Well, the problem with that is the disadvantages. A plaintiff will then want the disadvantaged settling party to cover the other guarantor's portion, because that person can never be pursued again. Again, our case law is very black letter when it comes to guarantees. because you shouldn't have to attempt to prove these types of issues. Are the courts now going to open the can and now get into Rule 408 discussions among parties to try to figure out how somebody was disadvantaged or damaged? And that's why our black letter law is very clear on guarantees. I read a case, I think it was a case a number of years ago, that referred to guarantees as darlings of the law to be afforded special protection. And there's a reason why our courts have adopted black letter law for guarantees. Basically says the law of guarantees are strictly construed to limit the liability of the guarantors. A guarantor is released when the terms of their guarantee are altered without their consent and ambiguities are construed in their favor. And there's good public policy behind that. We shouldn't have to litigate guarantee cases like this. If the courts don't follow black letter law, like in this case, and say, Section 2.3 required Mr. Less to give a new guarantee. He didn't do that. Therefore, the Salmons parties are released. If the court doesn't follow that, we are now going to be litigating every guarantee dispute. And that's where the law of guarantees and black letter law is designed to avoid. We shouldn't be litigating every guarantee case.
I'm having trouble finding the ambiguity. It says that you have to sign a personal guarantee. Mr. Less says, I already signed one, I'm bound by it. Where's the ambiguity? I'm not sure. Does it say in the language of that modification agreement that you have to sign this long form guarantee, or you have to execute a new guarantee? I'm not seeing it.
It doesn't say that in the agreement. You're correct on that. But that was what all the parties understood to be the case, including the Salmons parties who relied on that. Now, nobody ever told...
Mr. Lesk signed the modification agreement. Clearly, he didn't understand it that way, because he signed this modification agreement. He actually signed it, and he says, no, I'm good. I signed the personal guarantee already. He didn't read it that way, did he?
We don't know, but that was never communicated to the Salmons parties. And that's important because the Salmons parties and all the other parties relied on Section 2.31, that there would be additional guarantees. And Mr. Salmons, before he was asked to sign the additional guarantees, he was told by Sir Mortgage, everybody else has signed off on the documents. You're the last one. So he had the understanding that Mr. Lesk had signed the same form of guarantee. And again, there is no issue of fact in this case. The title or the lender or the loan company that processed the transaction, Sir Mortgage, prepared the long form and gave it to everybody. Plaintiffs acknowledged they intended the guarantors to sign that. The Salmons parties acknowledged they intended that. The plaintiffs even filed this lawsuit trying to enforce the long form guarantee against Mr. Lesk. It wasn't until we were about 18 months into the lawsuit that the plaintiffs finally conceded, well, Mr. Lesk never signed the long form guarantee. And here's where we get to the black letter law of guarantees. They are darlings of the law. Basically, the law of guarantees is thou shalt not mess with the guarantor without the consent of the guarantor. And that's exactly what happened here.
But that's dealing with changing the debtor's underlying obligation. You can't change the debtor's underlying obligation that's being guaranteed by the guarantor without the guarantor's assent. And isn't that what happened in Indian Village and in Horrell? I mean, the underlying obligation of the debtor was changed without the assent of the guarantor.
Well, we do have that here, Your Honor. For example, if we look, Diane Galati, Salmons Brothers Framing, and SBC Inc., they were not prior guarantors under this case. They became guarantors based on the language of Section 2.3 and the reliance on that document.
The principal debtor's obligation change in any way under this modification agreement?
By the hypothetical I provided to you, the loss of bargaining power, the inability to resolve a case with somebody, yes. And I don't believe that the two cases, the Indian Village and the Horrell case, require a proof of damages or injury. It's very clear that
well,
if
they don't, but I mean, they do require somehow the debtor's underlying obligation changed, and the guarantor didn't agree to that.
Well, if we look at the Salmons Party's guarantees, the 3-page guarantees, compare them to the 3-word guarantee, this is a material change of the obligation. Under this new guarantee, there are all types of defenses that are being waived by the Salmons Parties. There's additional collateral being put up. That is much different than 3 words, quote, personally guaranteed by, end quote. And that is a material change. And the Salmons parties were anticipating that Mr. Lesk would be on parity with them under this agreement, and they weren't.
And I don't think you've answered my question yet. How is the debtor's obligation changed? You're talking about between the guarantors,
Correct.
co-guarantors, how they may be able to have leverage against each other, I don't know, possibly some type of contribution action. I understand all that. But the debtor's obligation that they're guaranteeing, did that change? in
That
modification?
didn't change, but debtor is synonymous with guarantor here. The guarantors are debtors under the case law. By signing the guarantees, they became debtors to the plaintiff in this case. So when you change the obligation of the guarantor, you are changing the obligation of a debtor in the case. Eventually, the plaintiffs figured out that Mr. Lesk didn't sign the long-form guarantee and that their case really wasn't going to go anywhere on that. So they devised a Plan B, and that Plan B was, well, let's mix and match the forms of guarantee. We're going to enforce the long form of guarantee against the Salmons parties, but the short form against Mr. Lesk. Well, the Salmons parties never agreed to that mix and match approach. They fully expected, as did everybody else, that the other debtor or other co-guarantor, Mr. Lesk, would be signing the same form of guarantee and put on parity with them. And again, this goes to public policy. Thou shalt not mess with a guarantor's obligations without the guarantor's consent. And the Salmons parties relied on Section 2.3 and the representations that were made to them that Mr. Lesk would be signing that same form of guarantee when they agreed to comply with that. I'd like to reserve the remainder of my time, if I may, Your Honors. Thank you very much.
Thank you, Counsel. Counsel for Appellee.
Thank you. Good morning, Your Honors. Roger Cohen on behalf of plaintiffs Appellees Flash and the Boys, LLC, and Al Schillinger. Also present with me is my partner, Kathy Sandweiss. Now, Your Honor, where I would like to start is a little bit of history. The suggestion is that the plaintiffs somehow misled everyone as to the status of the guarantees. What really happened is that the defendants started out with this deliberate two-pronged strategy where each was pointing the finger at the other to try to avoid liability. Mr. Lesk, in his deposition, testified that he did not execute a personal guarantee, that he told everyone at the meeting that he would not sign a personal guarantee, and that no one ever sent him a form of personal guarantee to sign. Now, based upon that testimony, Mr. Lesk
Said he never signed a personal guarantee?
he said he never signed a personal guarantee. In fact, his lawyers filed a claim against our clients for abusive process on the theory that we were suing on a non-existent guarantee. And yet there it is, Your Honor. Pretty incredible. There it is. He signed a guarantee. Now, what then ultimately happened is that 18 months into the case, the documents surfaced that showed that Mr. Lesk's testimony was just an outright lie, because he had indeed received a form of personal guarantee, and he did not say, I won't sign a personal guarantee. He said, I don't need to sign it, I already signed. And so the desperation here is not plaintiffs saying, well, we can enforce the guarantee that was signed and is binding and in effect. The desperation here is the defendants scurrying around trying to find a reason why they should not be liable, despite that Lesk signed a guarantee and the Salmons parties signed a guarantee. So that gets us to the issue of...
Well, at the point in time we're at, did Lesk ever get some benefit out of having refused to sign the long form but having only signed the...
No, Your Honor, because judgment was entered against him. And that's the issue. The issue here is materiality. There's some material difference between the three-word guarantee that Lesk signed and the long-form guarantee that the Salmons party signed. Now, Mr. Counsel says, well, in this hypothetical situation, it could impact negotiations. But there's no evidence of that. It didn't happen. And in fact, what is clear in the record is that a separate settlement was reached with the Salmons parties, because the Salmons parties acknowledged that by filing a notice of settlement with the court. The settlement blew up because the Salmons parties elected not to proceed, and the Salmons parties then filed a notice of termination of settlement agreement. But the evidence doesn't show that the plaintiffs were in any way hindered in entering into a settlement agreement. The record shows that the Salmons parties did not want to settle. So is it can the court, given the materiality condition, and I will address Judge Gould's question in a minute as to whether the debtor's obligations were modified. But if we assume that there was some modification, the modification has to be material. And whether you frame that in terms of injury, detriment, damage, there has to be something about the change that adversely affects the liability of the guarantor. And they simply can't show that in this case because of what we know, which is that the court found, and this had not been appealed from, that by signing off on this modification agreement in his corporate capacity, Mr. Lesk, and by extension Mr. Salmon, consented to the modification, and plaintiffs ended up with a judgment, a final judgment against Mr. Lesk. Mr. Lesk joined in this appeal, but only to the extent of filing a joinder in the Salmons party's brief. So there is no separate appeal from the judgment itself against Lesk.
He's basically conceded that he's liable on the
That's correct, Your Honor.
Guarantee.
That's correct. So we have a final judgment. What difference does it make that the final judgment comes from a short guarantee rather than a long guarantee? Would it have been great to have a long guarantee? Sure. But is there any materiality into that? Absolutely not. Now, they say that that everyone concedes that there were to be long form guarantees. Let me read from the response to request for admission, which is one of their key pieces of evidence that they suggest show that the plaintiffs made that concession. This is Exhibit 8 to item 420 in the court record on page 3. It was stated by one or more representatives of plaintiff that plaintiff's willingness to extend the loan would be subject to certain requirements, including the execution by less of a separate guarantee, which requirements were strictly for the benefit of and hence waivable by plaintiffs. So that's the misrepresentation here. It was certainly people were considering we wanted to get long form guarantees, but those requirements are in essence conditions. They were the lender's conditions that the lender was imposing as the consideration for granting the extension. Remember, the Marbach is the debtor. Marbach comes in and says we want more time to pay this debt. Marbach is given more time. And that's the effect of the modification, and in exchange for that, the lenders extracted an agreement from everyone to provide these different things, most of which they got, except that Lesk pulled his little fast one. But these are still conditions that the lender holds, that the lender can waive. Now, the court asked, is there something in that language that says that there have to be new guarantees? The answer, of course, is no. Nothing in the document that says that these are required, a specific form of guarantee is required. And if the lender, in its discretion, decides to waive that condition, it can.
Well, the question of newness would only arise as to Lesk, right? Because the other people hadn't
That's correct.
done any guarantee.
Now, and then here's where it gets more interesting. So let's say that everything had happened the way that Salmon says it was supposed to have happened. Okay? Lesk signed his personal guarantees, the Salmons signed their personal guarantees, and we get to the lawsuit, we get to trial. Would we be any different? Would things be different? The answer is obviously not. And among other reasons, we know that because the long-form guarantee that the Salmons parties signed contains waiver language that allows the holder of the guarantee to release other guarantors. So if we could release Lesk, we could release Salmons, why could we not change Lesk's form of guarantee? Why could we not change Salmon's form of guarantee? We're exalting form over substance here to say that there is something different about that long-form guarantee when the long-form guarantee that the Salmons parties signed themselves contains that kind of waiver language. And I might add that by signing the modification agreement, I may have said this already, the Salmons parties consented to the modification. That's the other issue here that they want to talk around. The Salmons parties are saying, well, we didn't sign. But they did sign, and that was the effect of the court's finding as to Lesk. Lesk's original theory was that he could cut himself down the middle, and that even though he consented to the modification on behalf of the debtor, Marbach, he didn't sign separately personally. So he could take the inconsistent positions. Well, yeah, I consented corporately, but I didn't consent personally. And the law is that you can't divide yourself up like that. And the court appropriately found that Lesk could not divide himself up like that, and therefore held him to his consent. And because he had consented, his guarantee remained in place. Because his guarantee remained in place, he's liable on the guarantee, and judgment was properly entered against him for the full amount of the unpaid debt. Hence, it's the Salmons parties who are still trying to avoid liability because of the absence of some additional different guarantee by Lesk incurred no detriment whatsoever by this transaction. They got exactly what they bargained for. Their debtor, their company, got an extension. The note subsequently matured. It was not paid on maturity, and now they're being called upon to honor the guarantee that they signed knowingly to induce that modification. There's nothing else going on. There's no reason to get thrown off track by the form of the guarantee.
So the hypothetical that you might treat the guarantors differently really is a herring at this point in time because you've got a judgment against Lesk.
That's correct, Your Honor. And it's not in the record. I mean, it's, I can make up hypotheticals all day long, but unless there's some evidence, that just doesn't mean anything. The court have any other questions about that issue?
No.
I would like to talk a little bit about the holder in due course issue, which was not discussed in counsel's presentation. The promissory note, and I appreciated being up there, is an unconditional promise of payment. As Marbach LLC agreed unconditionally to pay the sum of $1,168,880 to Deseret Sky Development or order. That is, by that language, that note falls within the definition of a negotiable instrument. It is an unconditional promise to pay a set sum of money to the bearer or order. The theory that keeps coming up is that this note was executed as part of a purchase contract for finished lots. And because we're told, and maybe we can assume, that the finished lots were never finished and delivered, there was a failure of consideration that prevents the holder of the note from becoming a holder in due course. The problem with that argument is that it's circular, and it subverts the whole concept of holder in due course. Our clients acquired this note for value, in good faith, and without notice of defenses. There's no evidence to controvert any of those three elements. What is said is that it was known to someone, presumably the mortgage broker, that the payment was conditional. It's not to say that there were defenses, because there were no defenses at the time. The argument is that everybody knew that there was this condition, that the note was in consideration for finished lots and that it would not become due until the finished lots were paid. But the problem with that is that it's not stated on the face of the note. The note is unconditional. If the debtor, if Marbach didn't want that note to be an unconditional promise of payment in the form of a negotiable instrument, there are two things it could have done to prevent that from happening. One is it could have been written right into the document, upon receipt of finished lots we will pay $1,168,000. Then it's not a negotiable instrument because it's not unconditional. Or it could have removed two words, or order. It's all they had to do is remove those words from the note and it becomes something other than a negotiable instrument. But they didn't do that. And not only did they not do that, but when Sir Mortgage came to Marbach and said, we're going to make a loan and we want to assign this note as collateral for the loan, they said, okay, we agree, we'll let you do that. And not only did they say we'll let you do that, but they signed an estoppel statement that said there are no defaults, there are no defenses. So what we have here is a classic holder in due course situation where the holder of the note, having acquired the note for value in good faith without notice of defenses, wants to enforce the note. The defendants don't like that because they have defenses against the original promisee. And for better or worse, the policy of the law is that those defenses can only be asserted as between the original parties, not against the holder in due course. As the commentator said, that note is the proverbial traveler without baggage. The defenses go away. And there is simply no reason under the law and no justification under the law for this finished lots defense to be raised in a lawsuit between a subsequent transferee / holder in due course and the original maker or guarantors. They can't get there. They try really hard by suggesting that there was some knowledge on the part of the mortgage company that could be imputed to the transferees. But that's when we spent an inordinate amount of time on depositions and discovery where they were trying to prove that the plaintiff somehow knew, or that there was an agency relationship, or that something that the plaintiffs intentionally bought a bad loan. There was some conspiracy to cheat the Marbach people by cutting off their defenses. And they came up with nothing. There's no evidence. So on the facts here, the plaintiffs are holders in due course. They're entitled to enforce that note free of any defenses. And there is no other answer. There are a number of other issues that are covered in the briefs. Does the court have any questions or anything else that you'd like to hear from us?
No, counsel.
I have nothing else then. Thank you, Your Honor.
Right. Counsel, Mr. Lasker, counsel for Mr. Lesk isn't here. Do you have any knowledge about that?
They've joined in our appeal. That's the extent of their participation, is my understanding.
We'll check on the notice. Go ahead, counsel.
It's important to understand that the guarantees also govern the relationship between the guarantors themselves. And that was changed without the consent of the Salmons parties. That's really important because my esteemed counsel hit the nail on the head. He said the Salmons parties' long-form guarantees contained waivers where, for example, the plaintiff could release Mr. Lesk but still hold the Salmons party's feet to the fire. It doesn't work the other way around if Mr. Lesk is held just to that 3-word guarantee. So it has placed, if nothing else, the Salmons parties in unequal bargaining power, and that is an injury, even though Indian Village and Horel don't require that. And it's something to which the Salmons parties did not consent, because...
But at this point in time, if in fact they have a judgment against Lesk, then you're not in dissimilar positions, other than the fact you're trying to avoid the consequences of the guarantor.
Well, respectfully, the judgment should have never been entered in the manner that it was. The judge concluded that the note and the modification agreement were a single document to be read together, and it does require the additional guarantee of Mr. Lesk. And everybody agreed the long form was what it was supposed to be. And by trying to enforce two dissimilar guarantees, the Salmons parties have been injured. Let me give you a hypothetical. What if Mr. Lesk had been given a form that said, your guarantee lasts only 1 minute after you sign it, and then it disappears? And the Salmons parties were never told about that. Would that be unfair? Absolutely. That's the type of injury that somebody can suffer, including the Salmons parties, when they're led to believe that there's going to be compliance with specific conditions and there aren't those conditions being satisfied. And again, proof of damages isn't required under the law. Now, my counsel spoke about settlement. Settlement fell apart for a number of reasons, but again, if we're not going to follow black letter law of guarantees, we're going to be getting into these types of arguments in every case. We're going to be having a talk about Rule 408 communications, how people were disadvantaged in settlements, why it couldn't settle. Was there disparate bargaining power? That's what the black letter law is intended to avoid. The courts are going to be flooded with having to decide every guarantee dispute if black letter law is not applied to protect guarantors in situations such as this.
Counsel, let me ask you a question on the waiver provision. I know in the long form guarantee it said that any of the guarantors could be released, be it the option to hold one or none of them. What would stop that from happening under the original guarantee?
Well, there's no language in the original guarantee under the note that allows.
But why the creditor then can't say, I'm not going to enforce your guarantee. I'm only going to enforce the guarantee against Salmons. Is there anything in the language of that original guarantee that says they could do the same thing?
It would automatically release Mr. Lesk as well.
How so?
Because there's nothing in Mr. Lesk's guarantee that gives the plaintiff the right to release the Salmons parties and still hold him to the guarantee.
Why can't a creditor just say, I'm not going to enforce the guarantee against you, I'm going to enforce it against Lesk only?
Well, if we use that hypothetical, we don't have that position here, because if they release Mr. Lesk, the Salmons parties are still stuck under the long-form guarantee, but not the other way around. And that's part of the problem. And if
I think Judge Gould's hypothetical went to the original note secured by a deed of trust. If the plaintiffs decided they only wanted to sue the Salmons and not Lesk, or the other way around, couldn't they make that determination without doing harm to the obligation?
No. If Mr. Lesk had signed the same long-form guarantee, they would then be on parity, and the parties would have all of their contribution rights, and they wouldn't be disadvantaged. Without being on the same long form of guarantee, the Salmons parties are disadvantaged. Another important thing to note on that as well is that originally the guarantee was between two parties, so they had equal contribution. By having the Salmons parties add another 4 guarantors, there's now an argument, what is the percentage of contribution among co-guarantors?
I understand your argument, counsel. Is there any quick point you want to make to wrap up here? You're out of time.
No, Your Honor. We just asked that the court apply black letter law of guarantees so that we don't have to litigate every single guarantee case that comes up. Thank you, Your Honor.
Thank you, counsel. We'll issue a written decision in due course. Court's in recess.